Okay, good morning. My name is José Emilio Pinto. I'm the tribunal chair. Some of you know me by Zoom. But this is, for us, it's very, very important to be back. We're extremely happy to be back in person after so many years using the platforms. I'm not blaming the platforms. They were extremely useful, but it's much better when we are sitting in the same room. So in the name of my co-arbitrators, Marcelo Cohen and John Beachy, and my own name, I would like to welcome you to this hearing, one of the very first in person. Also, I would like to welcome those who are attending this hearing remotely, especially the non-disputing party representatives that Marisa confirmed that they are already in attendance. So again, it's an enormous pleasure. It's great to be back. And we have to work. We have lots of tasks for the day, today or tomorrow. But first of all, I'd like to ask you to be very kind and introduce your colleagues who are attending this hearing here at the ICSID premises in DC. Claimant first.
Thank you, Mr. President. On behalf of the claimants, I'm Robert Sills of Pillsbury, Winthrop, Shaw, Pittman. With me are my colleagues on my left, Mr. Richard Deutsch, also of Pillsbury. To my right, Mr. Charles Conrad of our firm, Ms. Christina Friedman of Pillsbury, Ms. Elizabeth Dye, Mr. Derek Solar, and Mr. Martin Ruiz Garcia.
Thank you. Respondent, please.
Hi. Good morning, everybody. It's a pleasure being here in person. This is our first hearing in person, so we're very happy that thank you to the tribunal to making it happening. So I'm Claudia Frutos Peterson, partner Curtis Malé Prevost Colton Mosley on behalf of the Republic of Colombia. And I'm here with the Curtis team and the Agencia Nacional para la Defensa del Estado de Colombia. To my right is Ana Maria Ordóñez, the director. Then to my left, I have Fernando Tupa from Curtis, Elisa Botero from Curtis, Elizabeth Prado from the Agencia, Giovanni Vega from the Agencia, and of course, we have our terrific team of associates attending online, and they are all, their names are in the list of participants. Thank you so much.
Thank you very much. So,
and I'm sorry, Mr. President, I forgot to introduce you to my two colleagues in the back, Jackie Mesmer and Gabriela Sadler. Thank you.
Thank you. You are all mostly welcome. I would like to remind you that one of, this was highlighted by Marisa Planos Valero to you, but I'd like to highlight you that should you, for any reason, have any confidential matters to be addressed during the hearing, please let the tribunal know before you start so that we can decide and disconnect the remote attendance, okay? So unless you have any matters that you would like to address to the tribunal, I think we are ready to start. Mr. Sills, any matters?
We have no housekeeping matters, Mr. President.
Thank you.
We don't have any matters pending. Thank you, Mr. President.
So we start, we have 90 minutes now through 10:30, 10:40 for the opening presentation by respondent. So I think we can get started. And the floor is just yours.
Thank you, Mr. President. Good morning, Mr. Chairman and members of the Tribunal. Let me start by making some clear general remarks that are fundamental for the position of the Republic of Colombia. We signed the treaty with the United States of America, convinced of the benefits it would bring to our bilateral relations. It provides investors with the exceptional and rare opportunity to sue the state directly before investment tribunals like this one. This exceptional and expensive recourse to international adjudication should not be taken lightly. Colombia and the United States consented to accept claims from investors of the other party only when requirements of the consent are met. My mission today is to introduce Colombia's preliminary objections in the case brought by claimants on 6 December 2019. I would kindly ask the members of the tribunal to keep this date in your minds. Because Colombia invoked Article 1024 of the treaty, the first task of the tribunal is to decide whether, as a matter of law, the claim brought is a claim for which an award in their favor may be made. As a matter of law and accepting all facts in the notice of arbitration as true, the claim submitted is not a claim for which an award in favor of the claimants may be made under Article 1024 because, first, on 6 December 2019, when the notice of arbitration was submitted, there was no state measure capable of breaching a substantive obligation of the treaty or an investment agreement. Accordingly, there was no compensable loss or damage claimant could have incurred by reason of or arising out of a breach that did not exist. While 6 December 2019 is the critical date in the assessment of jurisdiction, as of today, there is still no measure capable of breaching the substantive obligations of the treaty or an investment agreement, and claimants have incurred no loss or damage by reason or arising out of a breach. The second task of the tribunal is to decide on the other 5 independent objections Colombia has raised against the jurisdiction of the tribunal, including the allegation that there is simply no protected investment in this case. Some of these objections were even raised by the state before the case was registered. As the tribunal can see, our agenda for the next 2 days is very busy and concerned with critical objections against its jurisdiction. This arbitration is novel for Colombia, since it is the first time it raises an objection according to Article 1024 of the treaty, and very much looks forward to learning from the decision of the tribunal in this respect. Now, claimants have taken issue with Colombia's preliminary objections, not only in this one, but in its previous cases. Awarding attorneys' fees and costs is requested by claimants as the proper way to discourage Colombia from raising preliminary objections in the future. As the head of the International Litigation Division of the Republic of Colombia, it is my duty to address this allegation, which is both unfair and very inaccurate. First, I would like to recall my colleagues that raising preliminary objections is a valid action under international law and an expression of respect for the peaceful settlement of disputes. Colombia has consistently appeared before international investment tribunals to honor its international obligations, but this does not entail a duty to refrain from vindicating the limits of its consent to the international jurisdiction. As far as investment arbitration is concerned, during the past 5 years under my direction, Colombia's practice has been characterized by a sincere respect and trust in investment arbitration. As a state committed to the rule of law, the terms of our treaties in their interaction with other relevant rules of international law have guided each and every aspect of our actions. Precisely because of that, and contrary to the positions advanced by claimants, Colombia has been successful when raising preliminary objections, including under this treaty. The present case is not an exception to Colombia's professionalism in approaching each step of the arbitral process. On the contrary, given the serious and numerous pathologies in the claimant's case, it was foreseeable, not to say mandatory for Colombia, to raise each and every single one of the preliminary objections it raised in these proceedings. As you can see, the time and costs used in these proceedings are not Colombia's fault, but the result of a notice of arbitration that was both premature and a reflection of serious breaches to the conditions of our narrow consent to investor-state arbitration. Let me finish with a brief general reference to the various agreements reached between Colombia and the United States of America regarding the interpretation of the TPA. Claimants have taken serious issue with Colombia's reliance on non-disputing party submissions and have argued that the NDP submission should be ascribed no legal value. In claimants' view, such agreements should be given no weight under the general rule of interpretation, given as supposed bias by the non-disputing party. Apart from the fact that the Vienna Convention, Article 31.3a, is explicit to the effect that subsequent agreements between state parties to a treaty are part of the general rule of interpretation, claimant's proposal leads to an unacceptable paradox. In this case, the more agreement would mean the less law, no law actually. In the claimant's case, despite having the highest possible degree of agreement regarding certain provisions in the TPA, such agreement would produce no law in the relationships between the parties. We truly hope the tribunal does not support this problematic proposition. With this, I conclude the introductory statement of the Republic of Colombia and kindly ask Mr. Chairman to give the floor to Ms. Claudia Frutos Peterson from Curtis to continue with our presentation. Thank you for your attention.
Thank you, Ana. Good morning, members of the tribunal and everyone else in attendance. Claimants have put themselves in an untenable position. They decided to launch a claim against Respondent preemptively before Colombia has taken any measure that could constitute a breach and having suffered no loss or damage as a result. Their intentions in bringing a claim prematurely are plain. They hope that an international arbitration will dissuade Colombia's authorities and specifically the CGR from exercising their constitutional and legal powers. Permitting such an abusive claim to proceed to the merits would not only undermine the legitimacy of investor-state arbitration, but directly contravene principles of law and the express language of the treaty. It is a well-settled principle that damage is an essential element of a cause of action. In this case, that principle is even more relevant because the two contracting states expressly agreed that a claim cannot be submitted to arbitration under the treaty if the claimant has not suffered a loss or damage. That is a hurdle that claimants cannot escape in this case, with the inevitable consequences that the claim is doomed from the start and must be dismissed in its entirety. The premature nature of claimants' claims is only the first of many reasons why the tribunal should dismiss this case. Respondent will go over each of one of those reasons later in this opening presentation, but before proceeding any further, let us briefly recap the relevant facts for the preliminary objections raised by Colombia. Claimants, FPGVC, which I will refer to as the joint venture, as a contractual association formed, it is a contractual association formed by the two other claimants, Foster Wheeler and Process Consultants, enter into a contract with Reficar to provide consulting services in respect of the management of a project to expand and modernize a refining complex in Cartagena, Colombia. Pursuant to that services contract, Reficar reimbursed the joint venture for all its costs and expenses in performing the consultant services and paid the joint venture a fixed rate for each man-hour work by the personnel assigned to perform the services, as well as a fixed profit for man-hour. The compensation structure set forth in the contract ensured that the joint venture recover all resources it used to provide the service to Reficar and guarantee a return linked to the number of hours worked, not to the success or to the failure of the refining project. The works for the expansion and modernization of the refinery were completed after years of delays and billions of dollars in cost overruns, leading the CGR, the Colombian state organ tasked with overseeing and controlling the expenditures of public funds, to initiate a fiscal liability proceeding to determine whether there had been an economic damage to the state, and if so, determine the amount of such damage and identify those responsible for causing it. The CGR's investigation led it to formally indict claimants, Foster Wheeler, and process consultants, as well as other Colombian and foreign juridical and natural persons and with fiscal liability. The indictment order, or as claimants call it, the CGR charges, was an administrative act of mere procedural character, marking the start of one of the mid stages of the fiscal liability proceedings. The indictment order charged 14 individuals and 5 juridical entities, including Foster Wheelers and process consultants, with joint and several liability for the economic damage to the state in connection with the refinery project. We must stop the story here. This is the moment when the claimants decided to submit their claim to arbitration, despite the fact that the indictment order was not a final act, not even at the administrative level, and that at that point in time, claimants have suffered no loss or damage as a result of Colombia's supposed breaches. As we will discuss in more detail later, this factual snapshot is crucial because determining the rightness of claimants' claim turns on whether respondents has breached an obligation and claimants had suffered a damage arising out of that supposed breach by the time claimants filed their notice of arbitration. Claimants' prayer for relief in the notice of arbitration is reflective of the fact that their claim was not ripe when they brought this case, because there was no measure capable of constituting a breach and claimants had suffered no damage arising out of respondents' supposed breaches. Their prayer for relief is forward-looking and completely speculative. They essentially asked the tribunal for compensation for supposed reputational damages, for an offsetting award in an amount equivalent to the total amount of damages established in an eventual ruling with fiscal liability, and for an injunction bearing the CGR from ever seizing the assets. But under Article 1026 of the treaty, the tribunal cannot award moral or hypothetical damages or grant injunctive relief, to say nothing of the fact that compensating claimants in an amount equal to the ruling with fiscal liability will give them a huge windfall, given that they have not paid a single penny towards satisfying that ruling. It really is astonishing that not only do they not seek compensation for actual damages, but want to make a profit at the expenses of Colombia. As the tribunal is aware, on April 26, 2021, the CGR ultimately issued a ruling with fiscal liability, finding claimants as well as other 14 another 14 others fiscal liable for the damage caused to the Colombian state. The ruling, which claimants refer to as the CGR decision, came out roughly a year and a half after claimants submitted their claim to arbitration. That, however, did not resolve claimants' predicament. Even today, 2 years after bringing this claim against Colombia, there is still no measure capable of constituting an international wrongful act and not resulting in damages for claimants. The truth is, rather than claimant's case, what has happened since the submitted of the notice of arbitrations helps defeat it. After bringing their claim, they initiated 2 acciones de tutela and filed an appeal against the ruling with fiscal liability, materially violating the waiver requirement in Article 10(18)(2) of the treaty. The recent initiation of a conciliation procedure against the CGR is an additional material violation of the waiver. And if claimants file an annulment action against the ruling with fiscal liability before the court of the administrative adjudicatory jurisdiction, as they have already said they will do if the conciliation fails, then that will constitute a further breach of the waiver for a grand total of 5 material violations of the waiver. At this point, it is obvious that claimant's so-called waiver is worthless and has no real effect. Claimants thought they could fulfill the requirements in Article 10(18)(2) of the treaty and engage Colombia's consents to arbitration by paying lip service. In the notice of arbitration, they included a waiver saying they will waive the rights to initiate or continue local proceedings with respect to the measures alleged to constitute a breach. But they also included a reservation that empties that waiver completely. And on top of that, they have acted since the outset of these proceedings as if no waiver existed at all, with the excuse that they are only acting defensively. The waiver under the treaty is categorical and contains no such carve-out. Realizing that the breach of the waiver is deadly to their claim and seeking to continue their participation in local proceedings in their observations to the U.S. non-disputing party submissions, claimant now argue that the measure alleged to constitute a breach of the treaty is the indictment order and not the ruling with fiscal liability or the fiscal liability proceedings more generally. They believe this distinction saves their case because the local proceedings they have initiated and continued refer to the ruling and the fiscal liability proceedings and not to the indictment order, meaning that under their flawed logic, there will be no violation of the waiver. But this belated distinction doesn't aid their case. In the course of these proceedings, claimants have continuously argued that the action of the CGR during the fiscal liability proceedings since the initiation of the investigation through the indictment order and up to the ruling with fiscal liability have violated the treaty. For example, in their application for provisional measures, claimants argue that the CGR decision and the CGR proceeding as a whole render claimants' contractual rights meaningless and violate claimants' right to fair and equitable treatment. Those are, according to the claimants, the measure at issue in this case. And so each of one of those actions they initiate or continue locally with respect to the fiscal liability proceedings constitute a violation of the waiver. The maturity of the claim is another issue altogether. As we have already explained, when claimants initiated this arbitration, which is when the maturity of the claim must be assessed, the physical liability proceedings had barely just begun. It is obvious that no breach of an investment treaty, let alone damages, could exist by the mere commencement of an administrative proceedings against an alleged investor. Before addressing each of respondents' preliminary objections, let us briefly discuss the scope and significance of the non-disputing party submission of the United States commenting on the meaning of various provisions of the treaty relevant to deciding those preliminary objections. The tribunal has before it the common and consistent positions of both contracting parties to the treaty on the interpretation of the provisions at issue in this case. The non-disputing party submission filed by the United States, coupled with Colombia's pleadings, is a subsequent agreement between the parties regarding the interpretation of the treaty or the application of its provisions under Article 31(3)(a) of the Vienna Convention of the Law of the Treaties. Simply put, a subsequent agreement is a consensus between the parties to a treaty reached after the entry into force about the interpretation of that treaty or the applications of the provisions. Since the parties are the masters of the treaty, such interpretation is, in the words of the International Law Commission's commentary on the Vienna Convention, an authentic interpretation by the parties which must be read into the treaty for purposes of its interpretation. The International Court of Justice echoed the ILC, stating that an agreement as to the interpretation of a provision reached after the conclusion of the treaty represents an authentic interpretation by the parties which must be read into the treaty for purposes of its interpretation. As the ILC explained in another report, if the parties to a bilateral investment treaty agree on an interpretation, that interpretation prevails and in itself takes on the nature of a treaty regardless of its form. Such an agreement collateral to the treaty must be taken into consideration in interpreting the treaty. The literature is consistent in establishing that a subsequent agreement does not require a special form of formality, a view that is shared by several investment tribunals. No single common act is required, as claimants wrongfully allege. In addition, to begin a subsequent agreement, the declarations of the contracting parties, in this case and in other cases, are also subsequent practice in the application of the treaty pursuant to Article 31.3b of the Vienna Convention. In fact, several investment tribunals have stated that the submissions of the contracting parties constitute subsequent practice regarding the interpretation of the provision of a treaty that is entitled to be accorded considerable weight. Colombia and the United States have consistently maintained the same positions, not only in this case, but also in other cases interpreting this very same treaty or other investment treaties that are similar or identically worded. The contracting parties to the treaty envisioned the participation of the non-disputing state for good reason. They wanted to make sure that the interpretation and application of the provisions of the treaty by the investment tribunals were consistent with the understanding of both contracting parties. Claimant's sole argument against giving way to the submissions of the United States seems to be that a non-disputing state party is not impartial because it is concerned it will face investment claims and so it will push for a limited interpretation of the treaty provisions. That argument is really nonsensical. If the contracting parties were concerned about facing investment claims, they would have not concluded the treaty in the first place. They also have the authority to amend or terminate the treaty if they so wished. What the contracting parties intended to achieve by allowing the participation of the non-disputing state in arbitration under the treaty was to avoid interpretations of treaty provisions that do not reflect their understanding. Realizing that the United States not disputing party submission in the case and in other cases are damaging to their claim, claimants try to undermine the importance by claiming that Colombia's preliminary objections are almost exclusively based on those submissions, implicitly suggesting that they contain interpretative positions that are isolated. Claimants are clearly wrong. Respondents' preliminary objections are based on the plain language of the treaty, supported by the U.S. non-disputing party submission on the interpretation of the treaty, and by more than 300 legal authorities. In short, as much as claimants dislike the submissions of the United States and the consensus reached by the contracting parties regarding the interpretation of the provisions of the treaty, they constitute an authentic interpretation that has binding force. Let us now turn to respondents' objections. Respondent has put forth two different categories of preliminary objections. On the one hand, respondent has raised an objection under Article 1024 of the treaty that as a matter of law, the claim submitted by claimants is not a claim for which an award may be made in their favor. That is because claimants failed to comply with the conditions set forth in Article 1016(1) of the treaty for the submission of a claim to arbitration, and because the relief they seek is not a relief that the tribunal can grant under Article 1026 of the treaty. In addition, respondent raised 5 jurisdictional objections that the tribunal decided to hear as a preliminary matter in conjunction with respondent's 1024 objection. First, respondent raised an objection that the tribunal lacks jurisdiction ratione materia because claimants do not have a protected investment under either the treaty or the ICSID convention, given that the contract they enter into is a pure commercial contract for the provisions of services. Second, respondent raised an objection that the tribunal lacks jurisdiction ratione persona over claimant FPGVC, the joint venture, because that claimant doesn't qualify as a juridical person under Article 25 2b of the ICSID Convention. Third, respondent raised an objection that the tribunal lacks jurisdiction ratione voluntatis with respect to claimants Foster Wheeler and process consultants because such claimants did not file a notice of intent as required under Article 1016(2) of the treaty. Fourth, respondent raised an objection that the tribunal lacks jurisdiction ratione voluntatis respect to the claims for breach of the treaty's FET obligation because Foster Wheeler and process consultants made allegations to the same effect before Colombian courts and pursuant to Annex 10G of the treaty, such an election shall be definitive. And finally, respondent raised an objection that the tribunal lacks jurisdiction ratione voluntatis because claimants did not submit a valid and effective waiver pursuant to Article 1018 2b of the treaty, and because they have acted inconsistently with that waiver in at least 4 instances. As I said, they have filed 2 acciones de tutela before Colombian courts, an appeal against the ruling with fiscal liability before the fiscal chamber of the CGR, and just recently, they initiated a conciliation procedure before the Procuraduría, which is a procedural precondition for initiating an annulment action before Colombian courts against the ruling with fiscal liability. Members of the tribunal, drawing a distinction between the 2 categories of preliminary objections raised by respondent is crucial because the treatment of the facts and the standard applicable to each category is entirely different. To rule on respondent's 1024 objection, the tribunal must look to claimant's notice of arbitration and decide whether the claim thereby submitted is a claim for which an award can be made in claimant's favor, assuming as true their factual allegations in that notice of arbitration. To rule on respondents' other jurisdictional and admissibility objections, the tribunal must look at the facts, make any relevant factual determinations, and decide each objection taking into account that claimants have the burden of proving all facts supporting their case on jurisdiction. In the written and oral submissions, claimants consistently ignored this key distinction and conflate the 2 standards. They want this tribunal to take them at their word, presuming as true every single one of their allegations, both factual and legal. Unfortunately for claimants, that is not how things work. We will discuss each standard separately later in this opening presentation before addressing each category of preliminary objections, but I want to leave you with one final thought before we move on. Claimants have employed a truly questionable strategy in these proceedings, constantly undermining respondents' due process rights and increasing the cost of defending this case. First, claimants have made a habit of speaking out of turn and out of scope. The record is full with instances where claimants exceeded the bounds of the relevant submissions, trying to impermissibly include through the back door additional arguments or responses to Colombia's positions. Most noteworthy is claimants' request for provisional measures and an emergency temporary relief a 64-page document accompanied by 4 witness statements and 79 exhibits, which was plainly a memorial on the merits poorly disguised as an application for interim measures. Just a few weeks ago, claimants took advantage of the opportunity to provide comments on the U.S. submission to come up with new arguments in an attempt to fix their flawed claim. Second, claimants have made arguments that fly in the face of the language of the treaty and continuously shifted their positions as they go along. 2 examples easily come to mind. Claimants filed a request for provisional measures seeking to enjoin the application of the same measure alleged to constitute a breach of this treaty, directly contradicting Article 1028 of the treaty. In fact, their shifting stance as to the measures alleged to constitute a breach, which we discussed earlier, is a prime example of how claimants have moved the goalposts at every turn in this case. Another example is their expropriation claim, which has changed significantly since the case started. They started out claiming that Colombia had expropriated 2 specific clauses of the services contract. After respondent explained why such an expropriation claim could not be succeeded, claimants now offer a very different formulation. In fact, respondents will not be at all surprised if this afternoon, during their opening statements, claimants offer a completely new theory of the case, raising entirely new arguments for the first time since this arbitration started. If that were to happen, and respondents fortunately thinks that it will happen, Colombia's due process right will be severely impaired. Logically, Colombia can only defend against claimants' claims as they originally pleaded. And while their tactics are disruptive and violate Colombia's rights of defense, they only reveal that their case is flawed and bound to fail. This claim should not have started in the first place and has certainly gone far enough. Colombia requests that the tribunal upholds respondents' preliminary objections and dismiss this case in its entirety. I will now address Colombia's 1024 objection. Article 1024 of the treaty provides that the tribunal shall address as a preliminary question any objections by the respondent that as a matter of law, a claim submitted is not a claim for which an award in favor of the claimant may be made under Article 1026. This preliminary objection is intended to dismiss at an earlier stage of the arbitral proceedings legally defective claims such as the one filed by claimants. Before we discuss why claimants' claim is not a claim for which the tribunal can make an award in their favor, let's look into the standard applicable to deciding on respondents' 1024 objection. Article 1024C states that in deciding an objection under this paragraph, the tribunal shall assume to be true claimants' factual allegations in support of any claim in the notice of arbitration. The first thing to note about this standard is that the presumption of truthfulness in Article 1024C only applies to claimants' factual allegations. It doesn't apply to claimants' legal allegations or conclusions that are unsupported by factual allegations. This is a hotly debated issue between the parties because claimants want the tribunal to take every single line of argument as a factual allegation. But not every allegation made by claimant is a factual allegation that the tribunal must accept as true. Claimants' attempt to unduly expand the limited scope of this presumption of truthfulness must fail. Let's look at a couple of examples. Claimants state, and I quote, FPGVC was not a fiscal manager under Law 610, and there is no curable basis upon which it could be asserted to be one. This is not a factual allegation. Whether FPGVC qualifies as a fiscal manager is a legal allegation that the tribunal must not and cannot accept as true. I will give you another example. Claimants state that if the investigative party is not a fiscal manager, the CGR does not have jurisdiction to initiate a fiscal liability proceeding. That is also not a factual allegation, but a legal allegation. Let us see one example of a true factual allegation made by claimants. Claimants state that CV&I eventually completed the project in July 2016 according to specifications, but at total cost of about 6.1 billion US dollars, nearly 3 years late and more than a double its original estimated cost. Now, that is a factual allegation. It is an allegation about a fact, about an event or thing that may have existed or occurred. Under paragraph C, only the factual allegations in the notice of arbitration benefit from a presumption of truthfulness. As the tribunal in PAC-RIM versus El Salvador correctly pointed out, the presumption of truthfulness is limited to the factual allegations raised by claimants in their notice of arbitration and does not extend to factual allegations made elsewhere. Claimants, of course, rally against this rule, accusing respondent for being formalistic and arguing that it's an accepted principle that a tribunal should take account of developments since the case was commenced. But claimants conflate what are clearly two separate issues. The presumption of truthfulness in paragraph C applies only to factual allegations in the notice of arbitration because it is the notice that claimants submit their claim, and thus it is where the tribunal must turn to decide over an objection that a claim submitted is not a claim for which an award in favor of the claimants may be made. A separate issue is whether developments after the submission of the claim can be considered by the tribunal in deciding the merits. The issue is currently not before this tribunal. In addition, respondent is not saying that claimants may not offer clarifications after filing the notice of arbitration, but those supplemental facts do not benefit from a presumption of truthfulness. Finally, in deciding respondent's Article 1024 objection, the tribunal may consider other relevant facts that are not in dispute between the parties. The United States shares this interpretation of Article 1024C. In the rejoinder, claimants argue that in order to uphold respondent's 1024 objection, the tribunal has to find that claimants' claims are certain to fail. But that standard is nowhere in the text of Article 1024. In fact, the reality is that the tribunal in Corona versus the Dominican Republic dismissed a claim involving a factual pattern very similar to this case, where the claimant was challenging an administrative act that had not yet been subject to judicial review. The Corona Tribunal dismissed the claim under a provision identical to Article 1025 of the treaty, which is a more limited review mechanism that Article 1024 due to its expedited nature. What the tribunal needs to do here is to determine whether the claim presented by claimants in the notice of arbitration is a claim that as a matter of law can end with an award in their favor. The simple answer to that question is no. As a matter of law, claimant's claims is not a claim for which an award may be made in their favor for two reasons. First, because claimants failed to comply with the conditions set forth in Article 1016(1) of the treaty for the submission of a claim to arbitration. And second, because the relief they seek is not a relief that the tribunal can grant under Article 1026 of the treaty. We will review each of these reasons separately. Let's start with the first of those reasons. Under Article 1016(1) of the treaty, in order for an investor, either on his own or on his own behalf or on behalf of an enterprise that owns or controls directly or indirectly, to submit a claim to arbitration under the treaty, two requirements need to be met. A, that there be a breach of a substantive obligation under the treaty or an investment authorization or investment agreement, and B, that the claimant or enterprise has incurred
loss or damage by reason of or arising out of such breach. Failure to comply with these essential requirements affects not only the admissibility of the claim submitted to arbitration, but also the consent itself, since Article 10.17.1 of the treaty, since according to Article 10.71 of the treaty, the contracting parties only consent to the submission of a claim to arbitration under that section in accordance with this agreement. That was expressly acknowledged by the tribunal in UPS versus Canada when they were interpreting a very identical provision. Whether the requirements of Article 1061 of the treaty for submitting a valid claim to arbitration are met, and by extension, whether a claim is ripe, must be assessed at the time the claim is submitted to arbitration. That was the holding in Glamis versus the US, where the tribunal interpreted a provision of NAFTA that is almost identical to Article 10.16.1 of the treaty. That is also the position of the United States in various of the non-disputing party submissions. And in fact, in the submissions that the United States made in this case, they clearly says so. I quote, "The breach and loss must have already occurred prior to the submission of a claim to arbitration." And they continue saying, "No claim based solely on a speculation as to future breaches or future loss may be submitted." That is why events or damages that occur after the initiation of the arbitration are not relevant to determine whether the requirements of Article 10.16.1 of the treaty are met. In their rejoinder, claimants argue that the tribunal should take account of developments since the case was commenced. That is totally incorrect. As the tribunal in Glamis put it, the issue of ripeness turns on the determination of whether the challenge measure had effected harm by the time claimant submitted his claim to arbitration. Therefore, in determining the ripeness of claimant's claim, the tribunal must look at the facts as they stood at the time claimants filed their notice as arbitration. Claimants take issue with the actions of the CGR within the context of the fiscal liability proceedings. So what had happened in the fiscal liability proceedings when claimants submitted their claim to arbitration? Let's look. On your screen, we are displaying a timeline on the main dates and events of the dispute. In the middle is the filing of the notice of arbitration on December 6, 2019, which is the key date for purposes of determining whether claimants comply with the requirement of Article 10.16.1 of the treaty. The facts to your right of the screen, which occur after claimants file the notice of arbitration, are wholly irrelevant to the question of ripeness. Assuming as true claimants' factual allegations in the notice of arbitration, the tribunal must answer two key questions. One, by December 6, 2019, was there a prima facie breach of a substantial obligation under the treaty or of an investment authorization or investment agreement? And two, by December 6, 2019, had claimants incurred a prima facie loss or damage by reasons of or arising out of such a breach? The answer to both questions is a resounding no. By the time claimants submitted the notice of arbitration, there was no measure capable of constituting a prima facie breach, and claimants have suffered no prima facie loss or damage as a result. Today, more than 2 years after this case started, the situation is still the same. There is no measure capable of constituting a breach and no associated loss. The claim is still not ripe. Let's start with the measure under this article. Why do we say that claimant's claim is premature? Because when claimants initiated this arbitration, there was no measure capable of constituting a breach of a substantive obligation of the treaty and causing damage to claimants. At the time the notice of arbitration was filed, the fiscal liability proceeding was midway, and the CGR had made no final determination on claimants' potential fiscal liability. When the claimants decided to initiate this arbitration, the CGR had merely issued the indictment order, or the CGR charges, to take claimants' terminology. As Respondent has explained repeatedly, an indictment order is an administrative act whereby the CGR identifies the allegedly fiscal liable parties, kicking off an evidentiary period during which the CGR will gather the evidence necessary to rule on the fiscal liability of the parties named in such indictment order. Because the indictment order is not an administrative act, it is an administrative act of mere procedural nature that does not define any legal situation, it cannot possibly breach Colombia's international obligation under the treaty. The ruling with fiscal liability is also not a measure capable of constituting a breach of Colombia's substantive obligation. It was rendered well after claimants initiated this arbitration and thus cannot be taken into account in deciding whether claimant's claim was ripe when commenced. But even if the tribunal were to take the ruling into account, such ruling cannot constitute a breach of the treaty because it is also an administrative decision that is subject to judicial review, and such review has yet to take place. As the United States rightly observes in a submission, and I quote, "It is well established that the international responsibility of states may not be invoked with respect to non-final judicial acts. No final judicial acts cannot be the basis for claims under the treaty." Indeed, not every mistake by an authority can be given rise to an international wrongful act resulting in state responsibility. A state cannot possibly ensure the legality and adequacy of every one of the decisions taken by authorities at every level. But states, including Colombia, have mechanisms in place to correct those mistakes. And until those mechanisms are allowed to operate, and if they ultimately fail, it cannot be said that there has been an act of a state capable of triggering international responsibility. In this case, taking claimants' factual allegations as true, there was not even a final administrative decision rendered by Colombia's authorities at the time that this arbitration was initiated. Thus, it is impossible for a treaty breach to have existed at that time. Even now that there is a ruling with fiscal liability, which is final at the administrative level, there is still no measure capable of constituting a breach of Colombia's obligations under the treaty because the ruling with fiscal liability is subject to judicial review. Claimants take issue with respondents' position, alleging that Colombia is reading an exhaustion of local remedies into the treaty that the treaty doesn't contain. But claimants' argument is a red herring. The fact that the treaty doesn't procedurally require the exhaustion of local remedies before initiating a treaty claim doesn't mean that exhausting local remedies is not substantially required in order to find that there is a violation of certain obligations of the treaty. It is simply not possible that a state could be found international liable by an international tribunal when domestic courts have not yet been able to review an administrative decision, let alone when there was no definite administrative ruling when claimants filed their claim. As the United States correctly points out in the submission, there has to be a final act that is sufficiently definite to implicate a state's responsibility. In this respect, this case is analogous to Corona versus Dominican Republic, where the tribunal found that a treaty breach could not exist before the claimant pursued judicial remedies under domestic law. As the tribunal held in Corona, when a claimant is successfully made out of an international law, it is because the International Court of Tribunal accepts that the respondent's legal system as a whole has failed to accord justice to the claimant. The premature nature of claimant's claims dooms their case. Arbitral tribunals have consistently rejected for alleged breaches of treaty obligations when such claims have been raised prematurely. Claimants were not able to distinguish any of the numerous decisions cited by Colombia in these proceedings. As the tribunal reasoned in Acmea versus Slovakia too, a tribunal should not engage in a speculative exercise looking into the future to examine a state conduct that has not yet materialized. In short, since there was no measure capable of constituting a breach of any of the substantive obligations of the treaty at the time claimants filed the notice of arbitration, claimants' claims are premature and could not be brought under Article 10.16.1 of the treaty. Let us now turn to the two specific requirements under Article 10.16.1. I will start with the second one. For an investor to submit a claim to arbitration under the treaty, claimants must have incurred loss or damage at the time that the notice of arbitration was filed by reasons of or arising out of the supposed breach of the treaty or investment agreement. This express requirement reflects a well-settled principle of law that damage is a key element of cause of action and is tending to bring a claim. This position is shared by the United States, who in its non-disputing party submission in this case stated that there can be no claim under Article 10.16.1 until an investor has suffered harm from an alleged breach. Again, the issue is one of ripeness. The contracting parties to the treaty wanted to make sure that claims that had not yet ripened because no damage had occurred could not proceed to arbitration. Well, on December 6, 2019, when claimants filed their notice of arbitration, claimants had not incurred a prima facie loss or damage as a result of Colombian supposed breaches of the treaty. Let us look again to our timeline. Even taking claimants' factual allegations as true, none of the actions of the CGR before the notice of arbitration has caused harm to claimants. And how could they, given that the indictment order is an administrative act of mere procedural character? That's where the analysis should stop, because as we have stated, the maturity of a claim is assessed at the time claimants initiated arbitration. But even if the tribunal were to look beyond December 6, 2019, the conclusions will be the same. The ruling with fiscal liability has not caused a prima facie harm on claimants, and any potential harm it may cause is completely hypothetical and speculative. That is because of the joint and several nature of the payment obligation in that ruling, and the huge difficulties faced by the CGR in attempting to collect payments from fiscal liable persons who, like claimants, have no assets in Colombia. Claimants know full well that they have not suffered any damages, and that without damages, they have no claim under Article 10.16.1. That is why they have tried desperately to fill in that gap by arguing that they have suffered reputational damages and by trying to manufacture new categories of damages, that is, their legal fees and costs in defending themselves in the fiscal liability proceedings. On the one hand, claimants assert that they have suffered reputational damages, but have offered no facts in support of the assertion. What is more, claimants have not shown prima facie that the reputational damages they claim arise out of claimants' supposed breaches of the treaty. In fact, Colombia has shown the opposite, that any reputational damages that claimants may have suffered do not stem from claimants' involvement in the fiscal liability proceeding, which is not even a criminal in nature, but from the more serious investigations of corruptions and bribery that Foster Wheeler and claimants' parent companies have been involved in various jurisdictions across the globe. Claimants themselves admit in the rejoinder that they were never charged with corruption or fraud in Colombia. claimants brush aside investigations to their parent companies, calling them irrelevant because the entities implicated in those cases are not parties to this case. That argument cannot be taken seriously since many investigations have named specifically branches of Amec Foster Wheeler. On the other hand, their legal fees and costs in defending themselves in the fiscal liability proceedings are not considered damages. Under Colombian law, attorneys' fees and legal costs are ordinary legal burdens to be borne by claimants as part of their cost of doing business in Colombia, not compensable damages. If legal fees and costs were considered compensable damages and the state were to reimburse every person it investigates for the legal fees and costs, the state could never launch an investigation. Moreover, as explained by the Chevron versus Ecuador Tribunal, legal costs incurred in local proceedings would have been incurred in any event, regardless of the alleged breach of the treaty. But thus, there cannot be a causal link between those legal costs and the alleged breach of the treaty. In any event, claimants cannot seriously think that they can comply with the ripeness requirement in Article 1016.1 by invoking their legal fees and costs in the fiscal liability proceedings as damages arising out of Colombia's supposed breaches of the treaty. A simple hypothetical reveals that claimants' characterizations of their legal fees and costs as damages is merely pretextual, designed to artificially check the box of Article 1016.1. Let's imagine a scenario where the CGR started investigating claimants, but ultimately decided not to charge them with fiscal liability. Would claimants start an international arbitration seeking to recover damages, the legal fees and costs associated with their involvement in the preliminary investigation, or even though they emerge victorious from that investigation? Of course they wouldn't. Claimants also argue that they satisfy the second requirement in Article 1061 because this is a case of future damages, and the tribunal in Mobile versus Canada made clear that future damages come within NAFTA Article 1116, which is essentially similar to Article 1016.1 of the treaty. In its reply, Respondent extensively addressed the discussion in Mobile and show why it doesn't assist claimants in this case. Essentially, in Mobile, the Mobile Tribunal defined future damages as damages crystallizing and becoming payable sometime in the future that result from a breach that began in the past and continue. We have a totally different scenario in this case. Claimants have no future damages, no breach has occurred, and so no resulting damages have begun. Their damages are purely hypothetical. There is absolutely no certainty that they will pay a single cent, either voluntarily or forcibly, in satisfaction of the ruling with fiscal liability. One final thought on the lack of loss of damage in this case. Claimants believe that because Article 1024C provides that the tribunal must assume as true their factual allegations, then to satisfy the requirements in Article 1061, it is enough for them to simply state that they have suffered loss. To accept claimant's position will be deprive Article 1016.1 of meaning, because a claimant could simply satisfy the requirements set forth in that article by alleging that there is a breach, there is a damage, and that there is causal link between the two. The tribunal must make its own prima facie determination on whether damages exist and cannot simply take claimants' allegations that they have suffered reputational damages as true. That's not a factual allegation. It's a mere conclusion unsupported by any relevant factual allegations that doesn't benefit from a presumption of truthfulness. Mr. President, if you consider appropriate, we can now make a break and then continue with our opening presentation. Thank you very much.
Thank you. Mrs. Fructus Peterson. We have scheduled 30-minute break. So we'll be back at 10:40. Should we start, Dr. Ordonez?
Yes, we can start. Thank you.
Okay, so you still have 1 hour and 20 minutes. Oh, sorry.
I apologize. Before we begin, we have a small housekeeping matter. Over the break, we noticed that the copy of this presentation provided electronically to us on the ICSID file sharing platform contains what appears to be a series of notes at the end that are not in the printed copy and are not in what's being displayed on the screen here. I assume those are private.
They were not intended to be shared.
And I wanted to assure you that we have not read them in any way, but I think it would be appropriate if a clean copy were to be provided and substituted.
Well, Bob, thank you so much. We apologize for that, and of course, thank you for letting us know. So yes, we will ask our team, probably they are listening to us, to remove that presentation from the box, or maybe Marisa, you could, you can delete it.
I can delete it now.
Yes, and we can go ahead and uphold it. Thank you so much. Thank you, appreciate it.
Thank you. Well, you still have 1 hour and 20 minutes to complete your presentation.
Thank you, Mr. President. Mr. Fernando Tupa will continue with our opening.
Good morning, members of the tribunal. I will now address the absence of a prima facie breach in this case, as well as the rest of respondents' arguments under Article 1024. I want to go back to the two requirements under Article 1016.1 of the treaty. We have covered the second requirement. Now let's look at the first. The first requirement under Article 1016.1 is that there be a breach of a substantive obligation of the treaty, an investment authorization, or an investment agreement at the time of submission of the claim. On the date of the notice of arbitration, assuming as true all the factual allegations put forward by claimants in such notice, there could not have been such a breach. Let's discuss the potential breach of the treaty's substantive obligations first. Claimants have failed to establish in their notice of arbitration that their claims constitute a prima facie violation of the treaty's substantive obligations. Claimants complain about Colombia's prima facie analysis as a matter of principle, suggesting that respondent is asking this tribunal to evaluate the claims on the merits or turn this objection into a mini trial. To be clear, Colombia is not asking this tribunal to evaluate the merits of claimants' claims or to make any factual determinations about contested issues, as they wrongly suggest. Rather, Colombia requests that the tribunal analyze whether claimants' claims are legally defective. Respondent is calling on this tribunal to determine whether, assuming as true the factual allegations in their notice of arbitration, there could potentially be a breach of a substantive obligation of the treaty at the time claimants initiated this arbitration. If the answer is no, then the tribunal should uphold respondent's 1024 objection and reject the claim in its entirety due to claimant's failure to comply with the requirements in Article 1016.1. Obviously, in order to determine whether a particular set of facts are capable of constituting a breach of a treaty provision, the tribunal will first have to analyze the meaning and scope of these provisions. There is nothing impermissible about this type of review. It is an exercise that is perfectly within the scope of review allowed under Article 1024 of the treaty. As the tribunal in Corona versus Dominican Republic observed, an expedited procedure does not preclude a tribunal from considering an issue going to the substance of a case if the tribunal finds that it is appropriate to consider such an issue based on the facts as pleaded by the claimant, and in particular when its task is to interpret legal provisions. Simply put, Colombia submits that claimant's claims, even if the factual allegations advanced in their notice of arbitration were true, are not capable of constituting a breach of the treaty. Besides taking issue with respondents' prima facie analysis generally, claimants also dispute respondents' prima facie analysis of their specific claims. According to claimants' flaw logic, they have made a prima facie case of breach because they have claimed a breach, and respondent has failed to prove that there was no breach. But that's not how this works. A claimant has to formulate claims that are legally plausible on first impression, that pass muster on a prima facie basis. In other words, the question is, taking claimant's factual allegations as true, have they made a case for breach of the treaty's obligations? The answer is no, as we have demonstrated in our submissions and we will show now. Let's start with their claim of breach of FET. Claimants have not established a prima facie breach of the FET obligation for several reasons. The first of those reasons is that Article 10.5 of the treaty only applies to investments, not to investors, and all of claimants' claims pertain to alleged actions by Colombia that affected investors. Article 10.5.1 of the treaty unequivocally provides that each party shall accord to cover investments treatment in accordance with customary international law, including fair and equitable treatment and full protection and security. The text of this provision is clear and unambiguous. The protection is only granted to cover investments, which is a defined term in the treaty, not to investors. The language of this provision stands in stark contrast with the language contained in the national treatment and MFN obligations under the treaty, which protect both investors and cover investments. An interpretation of the FET provision in accordance with Article 31 of the Vienna Convention, namely pursuant to the ordinary meaning of its terms in their context, does not leave room for any other interpretation. Respondent submits that to read into the provision terms that it does not contain would be no longer to interpret it, but instead to rewrite it, which the tribunal cannot and should not do. That this provision only protects investments is also the understanding of the United States, the other contracting party to the treaty. In its non-disputing party submissions, interpreting the meaning of this very same treaty provision, the US has repeatedly held that Article 10.5 requires the parties to accord fair and equitable treatment and full protection and security only to cover investments, not to investors. What's more, the law firm representing claimants advanced the exact same argument when they were representing Mexico in another investment arbitration case. In Lyon versus Mexico, the respondent argued that Article 1105 of NAFTA, which is identical to the provision at issue here, quote, extends protection to investments, but not to investors, end quote. In certain cases, the difference may be immaterial, since the alleged measure could affect both the investment and the investor. However, in this case, none of the allegations made by claimants in their notice of arbitration are related in any way to a services contract, what claimants claim as their cover investment, but rather to actions that could have only affected the investors. Thus, even if claimants' factual allegations were true, the FET standard could not have been breached since Colombia's alleged actions could only have affected the investor, not the investment. Claimants concede that the FET standard under the treaty is limited to the minimum standard of treatment under customary international law. However, the parties do not agree on whether the minimum standard has evolved since NIR, and in particular on whether the minimum standard includes the concept of legitimate expectations, which clearly does not, as the International Court of Justice confirmed in the landmark case Bolivia versus Chile. But the tribunal doesn't need to get caught up in this discussion about the standard, since claimants' claim does not even meet their own version of the standard. For instance, in order to consider whether legitimate expectations exist, those purported expectations must be objectively analyzed at the time of making the investment, must be reasonable, and must be based on specific promises to the investor. Claimants do not even allege in their notice of arbitration that there was a specific promise made by a government official at the time of making their investment upon which they relied in making said investment. Thus, none of the factual allegations made by claimants could have violated any alleged legitimate expectations. With the exception of a denial of justice claim, which we'll address next, claimants have not identified any other theory or element of FET that might have been breached in this case. None of claimants' factual allegations could arguably constitute a violation of the minimum standard of treatment, in particular when no judicial action has been initiated to challenge the administrative decision of the CJR, which, as indicated, did not even exist at the time this arbitration was commenced. As to claimants' denial of justice claim, it cannot be seriously argued that a denial of justice existed when the notice of arbitration was filed. At that time, an administrative adjudicatory judicial proceeding had not even been commenced, and there was merely a procedural administrative act in an administrative proceeding that was just at its initial stage. Article 1052A of the treaty expressly provides that the FET obligation includes the obligation not to deny justice in criminal, civil, or administrative adjudicatory proceedings. The wording of this provision could not be clearer. The denial of justice protection only applies when there is an administrative adjudicatory proceeding, which is a proceeding of a judicial nature before courts with administrative adjudicatory jurisdiction. Thus, the obligation not to deny justice is limited in scope to judicial proceedings and does not extend to administrative proceedings. The fiscal liability proceeding initiated by the CJR is merely an administrative proceeding, not an administrative adjudicatory proceeding. In the rejoinder, claimants incorrectly allege that the term administrative adjudicatory proceeding, or procedimiento contencioso administrativo in Spanish, includes not only judicial proceedings, but also administrative proceedings. That argument is frankly absurd. The terms procedimiento contencioso administrativo in Spanish, or administrative adjudicatory proceeding in English, encompass judicial proceedings only. That is precisely why the treaty uses the terminology administrative adjudicatory proceeding, or procedimiento contencioso administrativo, and not simply administrative proceeding or procedimiento administrativo. Other provisions of the treaty, which are part of the context in which the ordinary meaning of the terms of this provision have to be interpreted, also confirm this rather straightforward interpretation. Whenever the contracting parties wanted to cover purely administrative proceedings, they used the terms administrative proceeding or administrative process, as they did, for instance, in Articles 10.8.4 and 10.9.3b2 of the treaty. Therefore, if the terms administrative adjudicatory proceedings or procedimiento contencioso administrativo in Article 10.5.2a of the treaty are construed pursuant to the Vienna Convention, it should be concluded that both the English and Spanish versions of the treaty have the same meaning and do not cover purely administrative proceedings. As claimants rightly point out, the Spanish and English versions of the treaty are equally authoritative, and according to Article 33.3 of the Vienna Convention, both are presumed to have the same meaning. In any event, we should not get entangled in this linguistical discussion, since a denial of justice requires, by definition, a final decision of the judicial branch of the state, and the standard to be met is extremely high. The fact that there are still multiple judicial remedies available to challenge the ruling with fiscal liability is by itself sufficient to show that claimants have not made a prima facie case of denial of justice. Claimants also take issue with the fact that Colombia challenges their bold assertion of futility regarding further Colombian proceedings. But the allegation of futility is not a factual allegation. It's a mere conclusion that is not supported by any factual allegation, and which does not benefit from the presumption of truthfulness. Claimants have not explained why the judicial review of an administrative decision would be futile. In fact, in its memorial, respondents showed that rulings with fiscal liability have been overturned in the past, both at the administrative and judicial level. It is worth recalling that claimants have not even filed yet an action challenging the decision of the CJR in Colombian courts. In sum, Even if claimant's factual allegations were true, there could not have been a denial of justice or any other type of FET breach at the time that they filed their notice of arbitration, since there was not even a final administrative decision in place, let alone a judicial decision of a Colombian court with administrative adjudicatory jurisdiction. Claimants have also not established a prima facie expropriation case. In their notice of arbitration, claimants allege that by initiating the fiscal liability proceeding, claimants expropriated two of their rights under the services contract, their alleged investment in this case. As respondent explained in its pleadings, which is consistent with what many investment tribunals have held, it is not possible to expropriate two discrete rights that are not capable of being economically exploited independently and separately from the purported investment, the services contract. In fact, it is a basic principle that an investment must be viewed as a whole for purposes of determining whether an expropriation occurred. Article 10.7 of the treaty expressly provides that no party may expropriate or nationalize a covered investment, either directly or indirectly, through measures equivalent to expropriation or nationalization. That is why the tribunal in Grand River versus the US stated that an act of expropriation must involve the expropriation of an investor, not part of an investment. A notion that was also confirmed by one of the cases cited by claimants, Koch versus Venezuela, where the tribunal graphically held that an investment cannot be sliced off and isolated like a piece of sausage. Notably, as the original expropriation claim was patently flawed, claimants have now radically changed their argument in the rejoinder and say that they have broadly alleged that Colombia has expropriated its investment, which consists not merely of the services contract, and that Colombia indirectly expropriated that investment by imposing a groundless penalty far exceeding the revenues realized. Well, that was certainly not the claim that claimants made in their notice of arbitration, which is the claim that the tribunal should consider for purposes of Article 1024, the Article 1024 objection. But it doesn't matter. This new formulation of the expropriation claim still fails. First, besides those two purported contractual rights, which in any event are still in effect, claimants did not make any factual allegation in their notice of arbitration that the services contract was affected as a whole by any action of the CGR or any other Colombian authority, or that any other unspecified investment made by claimants different from the services contract was somehow affected. The services contract was performed and claimants have been paid for the consulting services they provided. Second, claimants' allegation that the imposition of a penalty resulted in an indirect expropriation of their investment is an irrelevant argument. The ruling with fiscal liability did not exist at the time that claimants filed their notice of arbitration, and even if it were to be taken into account, claimants have never paid a dime of such penalty, so they could not claim that any revenues were taken from them. In any event, the two contractual provisions that claimants originally alleged were expropriated have nothing to do with the actions of the CGR or claimants' fiscal liability. Those provisions bind the joint venture and Reficar only as parties to the services contract. In sum, both claimants' original and their new expropriation claim are not capable of constituting a prima facie breach of the treaty. Claimants have also failed to establish a prima facie breach of the national treatment obligation under the treaty. The fiscal liability proceeding involved both nationals and foreigners, and thus there is no action or measure that has prima facie favored nationals over non-nationals. There seems to be no dispute in this case about the scope of the national treatment obligation, which is set forth in Article 10.3 of the treaty, and which protects investors of the other contracting party against nationality-based discrimination. The dispute lies on the application of this standard. Claimants' claim for violation of the national treatment obligation is entirely based on the fact that the CGR did not charge the members of Ecopetrol's board of directors with fiscal liability, while it did charge Foster Wheeler and Process Consultants, despite the fact that both were according to claimants, in like circumstances. Claimants allege that they were in like circumstances to the Ecopetrol Board of Directors because they were both involved in the project and indicted in the CGR proceedings. Likewise, claimants allege that the CGR treated claimants less favorably because they dismissed the Ecopetrol Board of Directors as not being fiscal managers, although they had actual decision-making authority over the project, but refused to dismiss claimants from the proceedings, though claimants were not fiscal managers. The assessment that they were in like circumstances is not a factual allegation benefiting from a presumption of truthfulness, but a legal conclusion. What are claimants' true factual allegations and the uncontroverted facts related to this standard? 1. The CGR charged both national and foreigners, including natural persons, such as the members of the board of directors and certain administrators of Reficar, and juridical persons, such as CB&I, with fiscal liability. 2. The CGR dismissed charges against both nationals and foreigners, such as CB&I and V. 3. The CGR issued precautionary measures against Colombian nationals, but did not issue precautionary measures against claimants. Based on those facts, there is no prima facie case of nationality-based discrimination, and so claimants have failed to establish a prima facie breach of the national treatment obligation under the treaty. Claimants have also failed to establish a prima facie breach of the most favored nation treatment obligation under the treaty. Claimants are not alleging here that there was another foreign investor that received a better treatment, but are merely trying to use the MFN clause of the treaty to import an umbrella clause, which does not exist in the treaty, from the Switzerland-Colombia BIT. Claimants attempt to use the treaty's MFN provision to import an umbrella clause must fail. First, Article 10.4 of the treaty, the MFN clause, merely requires a comparison of factual situations of treatment actually granted under similar circumstances. That was the conclusion arrived by the tribunal in Ishkale versus Turkmenistan when it had to interpret a similarly worded clause, reasoning that, quote, given the limitation of the scope of application of the MFN clause to similar situations, it cannot be read in good faith to refer to standards of treatment, standards of investment protection included in other investment treaties between a state party and a third state, end quote. Colombia submits that this is the correct interpretation of Article 10.4 of the treaty. In response, claimants argue that respondents' interpretation is prohibitively narrow. But that is not what the same law firm representing claimants thought when they were representing Mexico in another investment case in which they cited with approval the Ishkale case and alleged that there was a categorical impossibility of using the MFN clause to import standards of treatment from other treaties. Obviously, that interpretation does not suit their needs now. In this case, claimants do not allege that there was another foreign investor that received a better treatment, and thus no prima facie breach of the MFN clause could have possibly existed. Second, even if an importation of an umbrella clause from another investment treaty were to be theoretically allowed through Article 10.4 of the treaty, there are several reasons why such importation would not be possible in this case, which are explained in detail in our pleadings. But what is most striking about claimants' argument is that even if the MFN clause were to be applied in the way claimants propose, importing from the Colombia, Switzerland BIT a right to submit a claim to arbitration for breach of an umbrella clause would be inconceivable due to the fact that such right does not exist in the Colombia, Switzerland BIT. This was expressly confirmed by the tribunal in Glencore versus Colombia, one of claimants' favorite cases. It is quite telling that claimants barely mentioned the Switzerland-Colombia BIT in the rejoinder and now put all their eggs in a different basket, the Japan-Colombia BIT, which, by the way, was not mentioned by claimants in their notice of arbitration. However, this new argument makes no real difference since none of Colombia's treaties provide consent to arbitrate claims under an umbrella clause. Claimants are wrong when they state that the Colombian-Japan BIT allows for arbitration of umbrella clause claims. The text of the relevant provision establishes that the contracting parties consent to the submission of investment disputes, except for disputes with regard to the umbrella clause. Faced with this clear impossibility, claimants say that what they are trying to do is to import a substantive standard of protection without incorporating the dispute resolution provision of the Colombia-Japan BIT. But that argument overlooks the basic operation of an MFN clause. What claimants are trying to achieve is contrary to the very definition of the most favored nation obligation. The MFN obligation, contained in Article 10.4 of the treaty, only guarantees that U.S. investors will receive a treatment not less favorable than that accorded in like circumstances to Swiss or Japanese investors. It does not guarantee a more favorable treatment, which is what claimants want here. Such an application of the MFN clause would be contrary to the nature, content, and spirit of this treaty obligation. In sum, no prima facie breach of the MFN obligation under the treaty could have possibly existed here. Claimants have not only failed to make a prima facie case of breach of the substantive obligations of the treaty, they have also not raised a valid claim for a prima facie breach of an investment agreement. Claimants seem to believe that merely alleging that the CGR, through the fiscal liability proceeding, has deprived them of the protections under the services contract constitute a prima facie breach of an investment agreement. However, this allegation is fundamentally flawed. As a preliminary matter, there could not have been a breach of an investment agreement in this case because there is no investment agreement at all. Investment agreement is a defined term in the treaty, and Article 1028 states that it corresponds to a, quote, written agreement between a national authority of a party and a covered investment or an investor of another party on which the covered investment or the investor relies in establishing or acquiring a covered investment other than the written agreement itself. According to claimants' notice of arbitration, the services contract is their alleged investment, but the services contract cannot simultaneously be the written agreement and the covered investment, as the text of the treaty literally makes clear. That is also confirmed by Van de Velde in his often cited treatise, where he clarifies that the, quote, the investment established in reliance on the written agreement cannot be the written agreement itself, end quote. Claimants do not even attempt to deal with this threshold issue. Although this by itself should be dispositive of claimants' claim for breach of an investment agreement, the services contract is also not an investment agreement within the meaning of the treaty because it did not involve a national authority of a party, as such term is defined in Article 1028 of the treaty. Article 1028 of the treaty defines a national authority as an authority at the central level of government. Reficar, which is the party to the services contract, is not a national authority of Colombia. Under Colombian law, Reficar is a mixed capital company that carries out commercial activities belonging to the decentralized level of the Colombian government. Reficar's decentralized character is further confirmed by Annex 9.1 of the Colombia-US TPA on government procurement, which contains a list of central level of government entities that does not include Reficar or its parent company Ecopetrol. This decentralized status was recognized by claimants themselves in the Acción de Tutela 2018 that they initiated before Colombian courts. Claimants alleged that Reficar is a national authority and hope that the tribunal would take that supposed factual allegation as true. But asserting that Reficar is a national authority of Colombia is not a factual allegation. It is a legal allegation as to the application to Reficar of the term national authority of a party, which is defined in the treaty. As a legal allegation, it does not benefit from a presumption of truthfulness. In any event, even if an investment agreement did exist in this case, claimants' allegation for breach of an investment agreement is confusing and impossible to understand. Claimants have been changing and adjusting their arguments on this issue throughout their pleadings, and to this date, it is not clear what exactly claimants are claiming with respect to an alleged breach of an investment agreement. The fiscal liability proceeding concerns claimants' fiscal liability, not their contractual liability. Thus, no prima facie breach of an investment agreement was advanced by claimants. So to recap, claimants have failed to satisfy the two requirements set forth in Article 1016.1 to submit a claim to arbitration, and thus their claim is premature. At the time of the notice of arbitration, there was no prima facie breach of the treaty or an investment agreement, and no prima facie loss or damage to claimants resulting from that alleged breach. For that reason, as a matter of law, claimant's claim is not a claim for which an award may be made in their favor. As we mentioned earlier, there is a second reason why, as a matter of law, claimant's claim is not a claim for which an award can be made in their favor. Let's move on now to that second reason, which is that the tribunal is not empowered under Article 1026 of the treaty to grant any of the forms of relief requested by claimants. First, claimants seek an award of moral damages, but the tribunal does not, but the treaty does not grant the tribunal authority to award non-monetary or punitive damages. A tribunal constituted under the treaty can only issue an award subject to the limitations and exclusions provided in Article 1026. Article 1026.1 of the treaty provides that the tribunal is only empowered to award monetary damages, or daños pecuniarios in the Spanish version. And Article 1026.3 provides that a tribunal may not award punitive damages. Moral damages are generally viewed as non-monetary or non-pecuniary damages or as punitive damages. However, the discussion as to whether moral damages are punitive damages or non-monetary damages is irrelevant here and purely academic. The treaty prohibits the award of both punitive damages and non-monetary damages, making it impossible for the tribunal to grant moral damages to claimants, however characterized. Thus, the tribunal does not have the power to grant the moral damages that claimants request here. In addition, claimants requested in its notice of arbitration that the tribunal enjoin any attempt by the CGR or any other Colombian organ to seize any of claimants' assets in Colombia or elsewhere. Colombia explained that Article 1026 of the treaty does not permit the granting of non-monetary orders or injunctions such as those sought by claimants here. Moreover, Article 1028 of the treaty provides that the tribunal may not enjoin the application of a measure alleged to constitute a breach of the treaty. In their subsequent pleadings, claimants were silent on this point, implicitly conceding that the tribunal does not have the power to grant the form of relief originally requested. The third form of relief requested by claimants in this case is the issuance of an offsetting award equivalent to the amount of the ruling with fiscal liability, which this tribunal also does not have the authority to grant, since it is not empowered to award hypothetical damages or to make declaratory awards. Claimants have not made any payment of any amount of the fiscal liability determined in the ruling with fiscal liability, either voluntarily or forcibly. So there is no actual monetary damage that could be offset by the tribunal in an award. What's more, when this arbitration was initiated, there was not even a ruling with fiscal liability. In their provisional measures application, claimants themselves acknowledge that they have not yet suffered any damage. They acknowledge it yet again in the recent letter opposing respondents' request to include a new document into the record. The prayer for relief in the conciliation request is a further recognition that claimants' damages in the fiscal liability proceeding are purely hypothetical, and that they will only suffer actual damages if they make any payments in satisfaction of the ruling with fiscal liability. Until claimants actually make a payment to satisfy the ruling with fiscal liability, their damages will be merely hypothetical for three main reasons. One, the ruling establishes the joint and several liability of Foster, Wheeler, and Process consultants and the other fiscally liable parties, and thus it is impossible to know whether claimants will ever have to make any full or partial payment. Two, the ruling with fiscal liability is subject to several judicial remedies and could eventually be declared null and void. And 3, since the forced collection against Foster, Wheeler, and Process Consultants faces enormous legal and practical hurdles, it is possible that none of claimants' assets be identified, seized, and much less auctioned. Claimants have not even attempted to provide a substantive response to any of these threshold arguments raised by Colombia. It is frankly astonishing that not having paid a single penny to satisfy the amount of the ruling with fiscal liability, claimants are seeking more than 900 million in damages. Claimants now say that they're only seeking a compensation payment to be made for any assets seized by Colombia, and that they are not seeking a windfall because they are not asking for any recovery in excess of the assets actually seized. Well, it is undisputed that Colombia has not seized, much less auctioned, any of claimants' assets, and thus any offsetting award would be compensating merely hypothetical damages and would be granting claimants a windfall. As much as claimants like to assimilate this case to Glencore versus Colombia, they are worlds apart. In Glencore, the claimant voluntarily paid the ruling with fiscal liability, a fact which has been acknowledged by claimants themselves. In this case, claimants have made no payment whatsoever to satisfy the ruling with fiscal liability. Contrary to what claimants contend, this is not a question reserved for the hearing on the merits. Claimants are requesting a form of relief that this tribunal does not have the authority to grant, and thus their claim is legally defective. It is nonsensical to argue that the claim has to be fully aired when the form of relief requested by claimants cannot be granted by this tribunal. In sum, claimants' claim is legally defective, and thus it is not a claim for which an award in favor of claimants may be made under the treaty. Claimants did not comply with the requirements of Article 1061 of the treaty, and the relief they request is not a relief that the tribunal can award under Article 1026. For those reasons, the claim submitted to arbitration by claimants should be dismissed under Article 1024 of the treaty. This concludes our presentation on the preliminary objection under Article 1024 of the treaty. My colleague Elisa Botero will now address Colombia's jurisdictional objections. Thank you.
Thank you, Fernando. Good morning, members of the tribunal. In addition to Colombia's objection under Article 1024 of the treaty, respondent has raised 5 jurisdictional objections that should lead the tribunal to fully dismiss this case. Before we address each one, let's discuss the standard applicable to deciding those objections. As we explained earlier in this presentation, claimants lump all of Colombia's preliminary objections together, hoping that the tribunal will treat them all the same. But unfortunately for claimants, the presumption of truthfulness in subparagraph C is only applicable to decide 1024 objections. In the words of the United States, subparagraph C does not address and does not govern other preliminary objections, such as an objection to competence, which the tribunal may already have authority to consider. Such interpretation was upheld by the tribunal in Capes v. Guatemala, which stated that, unlike objections under Article 1024, jurisdictional objections do not require a tribunal to assume as true all facts alleged in the notice of arbitration. Rather, as the U.S. observed in its non-disputing party submission in Seo Hai v. Korea, which concerned an identical provision to Article 1024 of the treaty, the burden is on claimant to prove the necessary and relevant facts to establish that a tribunal is competent to hear a claim. The fact that the tribunal is to decide on respondents' jurisdictional objections as a preliminary question, together with an objection under Article 1024 of the treaty, does not alter that burden. Claimants attempt to avoid this burden by arguing that they are not required to present evidence at this preliminary stage of the proceeding. In their latest pleading, commenting on the U.S. submission, claimants go as far as to say that the parties supposedly agreed that all of respondents' objections, including its jurisdictional objections, quote, would be heard preliminarily without requiring an evidentiary submission, end quote. This is absurd. First, respondent never agreed to such a thing. Respondent simply requested that its jurisdictional objections be heard and decided as a preliminary question, together with its objection under Article 1024 of the treaty, as the treaty expressly allows. But more importantly, hearing jurisdictional objections at a preliminary phase doesn't mean that claimants are exempt from proving the necessary facts to establish jurisdiction. It just means that the jurisdiction of this tribunal is established before going into the merits. The evidence on jurisdiction is being heard now. This is what we have been doing for the past 2 years. During those 2 years, claimants had plenty opportunity to satisfy their burden of proof on jurisdiction. In addition to their notice of arbitration, which was accompanied by multiple exhibit and legal authorities, claimants had 2 full rounds of written submissions, as well as various other opportunities to submit additional evidence. Despite that, claimants had failed to prove the facts on which the jurisdiction of this tribunal is based. Let's now analyze each of claimants' Colombia's 5 jurisdictional objections that the tribunal will decide as a preliminary question. Colombia's first objection is that the tribunal lacks jurisdiction ratione materia because the services contract does not constitute a protected investment under the treaty and the ICSID convention. Article 1028 of the treaty defines investment generally as every asset that has the characteristics of an investment, including such characteristics as a commitment of capital or other resources, the expectation of gain or profit, or the assumption of risk. Article 1028 goes on to list several examples of the forms that an investment may take, including, under subparagraph E, different types of contracts, such as construction, management, and other similar contracts. However, that enumeration of assets is not dispositive. To qualify for protection under the treaty, an asset, including a construction, management, and other similar contract, must have the characteristics of an investment. Ordinary commercial contracts are excluded from the definition of investment because they do not possess the characteristics of an investment. This interpretation follows from a plain reading of Article 1028 and is also the interpretation of both contracting parties to the treaty. In its non-disputing party submission, in this case, the United States made it clear that ordinary commercial contracts for the sale of goods or services typically do not fall within the definition of investment. Under the so-called double-barrel test, for a tribunal constituted under the ICSID Convention to have jurisdiction ratione materia over a claim, the asset must not only qualify as an investment under the treaty, but it must also be objectively considered an investment under the terms of the ICSID Convention. Article 25 of the ICSID Convention provides that the jurisdiction of the center only extends to disputes of a legal nature, quote, arising directly out of an investment, end quote. Many ICSID tribunals have held that there is an objective notion of what constitutes an investment under the ICSID Convention. Under the test first developed by Salini v. Morocco, the assumption of risk is one of the essential elements of what constitutes an investment under the convention. Commentators and tribunals agree that ordinary commercial contracts are outside the scope of the center's jurisdiction. Thus, the assumption of risk, of an investment risk or operational risk, is one of the main characteristics of an investment under both the ICSID Convention and the treaty. It represents the uncertainty faced by an investor regarding the return it will receive on its investment, including whether or not it will recover in whole or in part the capital invested. This type of risk must be distinguished from generic risks inherent to any economic activity and from simple commercial risk inherent to any contract, including the risk of non-payment. As the tribunal in Roma v. Uzbekistan reasoned, all economic activity entails a certain degree of risk, but an investment risk entails a different kind of alia, a situation in which the investor cannot be sure of a return on his investment or may not know the amount he will end up spending, even if all relevant counterparties discharge their contractual obligations. Where there is risk of this sort, the investor simply cannot predict the outcome of the transaction. Similarly, the tribunal in Postova v. Greece explained that an investment risk entails an operational risk and not a commercial risk, a risk inherent in the investment operation in which the profits are not ascertained but depend on the success or failure of the economic venture concerned. Claimants have two main criticisms to Colombia's position. First, they argue without providing any support that the double keyhole approach to ICSID jurisdiction does not apply, and that therefore they need only comply with the definition in the treaty to gain access to the center. Claimants cannot simply ignore decades of ICSID jurisprudence on this issue. Claimant's second criticism has to do with the definition of investment in Article 1028 of the treaty. Claimants insist that the assumption of risk is not a necessary requirement for the existence of a covered investment, emphasizing the word or in the chapeau of the definition of investment in Article 1028. That argument is not only contrary to the express language of the treaty, but also to the very notion of investment itself. The assumption of an investment risk is the fundamental feature of an investment. It is what distinguishes an investment from an ordinary commercial contract. If a certain business operation entails a commitment of capital and an expectation of profit, but the party who committed that capital and expected a profit is not at risk of losing it and turning no profit, then there is no investment risk. That business operation is likely an ordinary commercial contract, but not an investment. The fact that the treaty uses the word or and including when listing the characteristics of an investment does not mean that the listed characteristics are not essential characteristics of an investment. It simply means that there are other characteristics in addition to those listed. That reading of the definition of investment is shared by the United States. Let's turn now to the facts. The question before this tribunal is simple. Is the services contract an investment? The answer to that question is no. The services contract between the joint venture and Reficar is, on its face, an ordinary commercial contract for the sale of consulting services that did not entail any investment risk. An analysis of the relevant contractual provisions inexorably leads to this conclusion. For one, the stated purpose of the contract is to provide consulting services for the management of the project, which included, among other services, the supervision and control of the detail engineering and of materials and equipment procurement for the project. The contract is an agreement for the provision of services, as claimants themselves have recognized countless times. Claimants insist that the services contract is a management or construction contract falling within the scope of subparagraph E, deceitfully equating management and construction, but the fact that the services contract is related to the provision of consulting services in connection with the construction and expansion of an oil refinery does not transform that contract into a construction contract. And even if it did, a construction contract is also not necessarily an investment. Regardless of how a contract is named, only contracts that have the objective characteristics of an investment qualify for protection under the treaty. In any event, the discussion about which is the best way to call the services contract does not have any practical significance. As the U.S. stated in its submission in this case, the determination as to whether a particular instrument has the characteristics of an investment is a case-by-case inquiry involving an examination of the nature and extent of any rights conferred under the state's domestic law. And there is no question in this case that the nature and the extent of the rights conferred under the services contract is that of an ordinary contract for the provision of consulting services. In addition to the purpose of the services contract, the provisions concerning compensation also show that claimants did not bear any investment risk. The remuneration structure in the services contract guaranteed claimants the recovery of all the resources they allocated to the performance of their obligations under the contract, as well as a profit. To recap what Colombia explained at length in its memorial on objections to jurisdiction, via the different components of the remuneration structure, the joint venture recouped salary costs for all personnel assigned to the performance of the services, whether foreign, expat, or local, non-salary costs for all personnel, including administrative overhead, taxes, and bonuses, direct costs associated with all personnel, including computer equipment, office leases, domestic and international call charges, office furniture, and relocation expenses, the cost of equipment, tools, materials, and software the joint venture deemed necessary for the correct performance of the services in Colombia, and I could go on. Besides recouping on all its costs, the joint venture charged a fixed fee for each hour worked by its personnel assigned to the services contract. In fact, as of the day of Respondent's memorial, the joint venture had received over $14 million in fixed fees from Reficar. That fee was 100% profit, since the joint venture recovered its costs through all its costs through the other components of the remuneration. In addition, by virtue of the tax gross up, the joint venture received Reficar's payments in full without any decrease for tax withheld at source. What's noteworthy is that claimants recouped their costs and earned a profit regardless of the outcome of the refinery project. Moreover, the joint venture received payment for its services on a month-to-month basis, as it was performing those services and had a right to unilaterally terminate the services contract in case of non-payment of invoices. There was no investment risk and therefore no investment because the remuneration structure provided for in the services contract ensured that the joint venture was never at risk of losing the resources it was allocating to the performance of that contract and had no uncertainty about the minimum return it would obtain. Claimants never disputed Colombia's description of the relevant provisions of the services contract. In 2 rounds of pleading, they outright refused to engage with the text of the contract because they are fully aware that it supports Respondent's position. Unable to deal with the nature and the terms of the services contract, claimants resort to all sorts of creative arguments to save their case, none of which assist them. First, claimants allege the services contract did entail risk, such as the risk of non-payment and termination, among others, and that the fact that there's a dispute here constitutes evidence of risk. However, as we've explained, every economic transaction entails some sort of risk, but not every risk is an investment risk. In fact, as a paper cited by claimants themselves explain, not every business dispute is an investment dispute because not every economic activity constitutes an investment. Second, in their rejoinder, claimants assert that they specifically faced an investment risk as set forth in ROMAC. That argument is frankly absurd. Claimants were assured a return on their investment because under the services contract, they received a profit per man-hour. Maybe they were not sure how much they would ultimately end up spending, but they were certainly sure that they would recoup every single penny of those expenditures. Whether they would be paid or not is a quintessential commercial risk, but that commercial risk in this case was practically non-existent because claimants invoiced monthly and had a right to terminate for non-payment of invoices. There is no such a thing here as the outcome of the transaction. They were hired to provide a consulting service, and for that they recouped their costs and were paid a fee. As simple as that. In the comments to the U.S. non-disputing party submission, claimants raised for the first time an additional reason why they believe the services contract entailed risk. They point to the bonuses provided in the services contract as additional evidence of risk. However, as Respondent explained in its memorial, those bonuses were mere commercial incentives that did not alter the remuneration structure, which guarantees claimants their cost plus a profit, as we've just reviewed. Third, claimants argue that the services contract is not their only relevant investment in Colombia, pointing to the amounts of time, capital, personnel, and labor they devoted to performing the services. But all those resources are not separate, quote unquote, investments unrelated to the services contract. Rather, those are the resources that the joint venture employed to comply with its obligations under the services contract. 4, claimants argue that they have a long history of investment in Colombia. That fact, whether true or not, is irrelevant. The tribunal has to decide whether the services contract is a covered investment under the treaty and the ICSID convention, not whether claimants' supposed prior investments qualify for protection. Finally, claimants contend that their supposed investments should be considered as a whole, looking at the totality of the project. That is wrong. Claimants' purported investment was the services contract, not any other contract within the framework of the project. In conclusion, the services contract does not qualify as a covered investment. Under the treaty and the ICSID convention, because there was no assumption of an investment risk, which is a quintessential characteristic of an investment, and thus this tribunal lacks jurisdiction ratione materia over the present dispute. Let's move on to Respondent's second jurisdictional objection. Respondent has raised an objection that the tribunal lacks jurisdiction ratione persona over the claims of claimant FPJVC, a contractual joint venture, because FPJVC is not a juridical person and therefore it does not qualify as a national of another contracting state under Article 25 of the ICSID Convention. This objection is rather straightforward. In order to qualify as a national of another contracting state under Article 25 of the ICSID Convention, a claimant needs to be a natural or a juridical person. According to Professor Schroyer, legal personality is a requirement for the application of Article 25(2)b, and a mere association of individuals or of juridical persons does not qualify as a juridical person under the ICSID Convention. Several ICSID tribunals have held that unincorporated joint ventures are not juridical persons because they lack legal personality. In Ampergillo v. Pakistan, the tribunal reasoned that the claimant, a contractual joint venture, was not a juridical person and had no separate legal personality, but because it was nothing more than a contractual relationship between different entities, holding that it had no jurisdiction ratione persona because the claimant failed to meet the requirements of Article 25 of the ICSID Convention. Foster Wheeler and Process Consultant expressly agreed in the joint venture agreement they executed that FPJVC would be an unincorporated entity. Under New York law, the law under which claimant FPG was formed, a contractual joint venture is recognized as a partnership for limited purpose and therefore does not have a legal personality separate and independent from that of its members, Foster Wheeler and Process Consultants. Because FPJVC is not a juridical person under New York law, it is also not a national of another contracting state under Article 25 of the ICSID Convention. In their rejoinder, claimants insist that the tribunal does have jurisdiction ratione persona over FPJVC, raising 3 arguments, all flawed. First, Claimants argue that the tribunal has jurisdiction because the treaty expressly references joint ventures within the definition of an investor of a party. However, under the double barrel test, an ICSID tribunal must be satisfied that a claimant meets both the criteria set forth in the relevant treaty and the ICSID convention in order to exercise jurisdiction. Claimants draw the tribunal's attention to the treaty, but ignore the ICSID convention altogether, ignoring the multitude of ICSID cases recognizing the existence of the double barrel test. The issue here is not whether FPJVC is an investor within the meaning of the treaty, but whether it qualifies as a national of another contracting state for purposes of Article 25 of the ICSID Convention. As Professor Schroyer stated in his well-known treatise, some bilateral investment treaties include associations without legal personality in their definitions of investor. But for purposes of the ICSID Convention, the quality of legal personality is inherent in the concept of juridical person and is part of the objective requirements for jurisdiction of ICSID. Second, claimants allege that contractual joint ventures qualify as juridical persons under New York law. That is simply wrong. Both parties agree that New York law governs this question and that under New York law, a contractual joint venture is treated as a partnership for limited purposes. However, the parties disagree on whether a partnership is a juridical person under New York law. Respondent has shown that under New York law, a partnership is not a juridical person because it does not have a legal personality separate and independent from that of its members. Claimants argue that a partnership is a juridical person because it can sue and be sued in its own name, hold property, and hold a nationality. Claimants are wrong in all three respects. The New York Court of Appeals, the highest court in the state of New York, has stated that although persons conducting a business as a partnership may be sued in the partnership name, unlike a corporation, a partnership is not a separate entity. Claimant's own legal authority confirms this. And while partnerships can hold property in their name, the members of the partnership maintain a direct interest in that property, which goes to show that the partnership is not a distinct legal entity separate from its members. As to nationality, the third restatement on foreign relations defeats claimant's argument, stating that, quote, under common law systems, a partnership is not an entity having nationality. Finally, claimants contend that Colombia considered claimants FPJVC a sufficient juridical entity capable of entering into the services contract. That is irrelevant to the issue of whether FPJVC is a juridical person under the ICSID Convention. In any case, as a matter of Colombian law, a joint venture, or consorcio in Spanish, has the capacity to enter into contracts with public entities, but is not a legal person. In short, claimant FPJVC is merely a contractual joint venture, which does not have legal personality separate and independent from that of its members. Because it is not a juridical person under New York law, FPJVC does not qualify as a national of another contracting state under Article 25 of the ICSID Convention, and so this tribunal does not have jurisdiction ratione persona over the claims of that claimant. Colombia's third objection is that the tribunal lacks jurisdiction ratione voluntatis over the claims of claimants Foster Wheeler and Process Consultants because they did not send a notice of intent before initiating this arbitration as expressly required by the treaty. Article 1017 of the treaty provides that each party consents to the submission of a claim to arbitration under this section in accordance with this treaty, while Article 1016(2) provides that at least 90 days before submitting any claim to arbitration under this section, a claimant shall deliver to the respondent a written notice of its intention to submit the claim to arbitration. Delivery of a notice of intent by the claimant is thus a precondition to the respondent state's consent to international arbitration. Note that the text of Article 1016.2 refers to a claimant in the singular, signaling that each and every claimant must deliver a notice of intent before submitting a claim to arbitration. The United States agrees with this interpretation. In its non-disputing party submission in this case, the U.S. stated that pursuant to Article 1017, the parties to the treaty did not provide unconditional consent to arbitration under any and all circumstances, and that a disputing investor that does not deliver a notice of intent fails to engage the respondent's consent to arbitrate. Very well. Of the three claimants in this case, only the joint venture sent a notice of intent prior to submitting the notice of arbitration. Claimants Foster Wheeler and Process Consultants did not send a notice of intent, which means they failed to engage Colombia's consent to arbitration under the treaty, depriving the tribunal of jurisdiction ratione voluntatis over their claims. Claimants argue that the notice of intent submitted by the joint venture provided notice for all three claimants because the joint venture comprises claimants Foster Wheeler and Process Consultants. They are wrong. The notice of intent only identified the joint venture as the investor claimant under the treaty and was submitted by the joint venture on its own behalf, not on behalf of Foster Wheeler and Process Consultants. That position is further confirmed by the notice of arbitration in this case, which states that each of the claimants qualified as a separate enterprise and investor under the treaty, meaning that each should have notified its own intention to submit a claim to arbitration. The fact that the joint venture is a contractual joint venture comprised by Foster Wheeler and Process Consultants is irrelevant. If the three claimants want to submit a claim against Colombia under the treaty, then each claimant must comply with the requirement of Article 1016.2. Foster Wheeler and Process Consultants cannot benefit from the notice of intent submitted by the joint venture on its own behalf. Claimants try to lessen the importance of the requirement in Article 1016.2, arguing that a formal defect in the notice of intent is not enough to destroy jurisdiction. Claimants are wrong. As a precondition to the state's consent to international arbitration, the delivery of a notice of intent is a mandatory procedural requirement, the non-compliance of which a tribunal cannot simply overlook. Several investment tribunals have held that preconditions and formalities, such as the notice of intent, required under Article 1016.2 of the treaty are not merely procedural niceties, but perform a substantial function. These tribunals have noted that such preconditions constitute a fundamental requirement that a claimant must comply with compulsorily before submitting a request to arbitration, and that their omission constitutes a grave non-compliance that prevents a tribunal from exercising jurisdiction. Notably, claimant's position here is completely at odds with the position that their counsel put forth in an investment arbitration where they acted on behalf of Mexico. In that case, Pillsbury argued that the failure by a claimant to comply with the requirement to deliver a notice of intent under NAFTA, which is virtually identical to the requirement under this treaty, meant that the submission was null ab initio and that therefore there was no consent under NAFTA. Claimants also attempt to minimize their non-compliance with Article 1016.2 by arguing that Colombia suffered no prejudice as a result of claimants Foster Wheeler and Process Consultants' failure to deliver a notice of intent. Whether respondents suffer or not a prejudice is beside the point. A claimant must comply with any and all formal requirements and preconditions to, quote unquote, perfect the respondent's state consent to arbitration. Those preconditions have been included in investment treaties for good reason and constitute an important safeguard, especially because we're dealing here with a waiver of the state's sovereignty. Claimants' attempt to shift the burden of proof to respondents should fail. There's nothing that Colombia needs to prove. The treaty is clear as to the requirements to state consent to arbitration, and it's for claimants to comply with those requirements. Finally, claimants contend that Colombia contradicts itself by arguing at the same time that the joint venture is not a juridical person separate from its members, and that the joint venture delivered the notice of intent on its own behalf. There is no such contradiction. Those are two separate and distinct issues. Each individual claimant, including the joint venture, must qualify as a national of another contracting state under Article 25 of the ICSID Convention. And each individual claimant, including Foster Wheeler and process consultants, has to comply with the compulsory requirement in Article 1016(2) of the treaty of delivering a notice of intent. It is claimant's position that it's patently contradictory. Claimants say that the joint venture is an investor under the treaty that is advancing a claim on its own behalf, but they argue that Foster Wheeler and process consultants should benefit from the notice of intent sent by the joint venture because they are members of that joint venture. Claimants cannot have it both ways. In conclusion, the tribunal lacks jurisdiction ratione voluntatis over the claims of the two claimants, Foster Wheeler and process consultants, due to the failure to deliver a notice of intent prior to submitting their notice of arbitration in this case. Colombia's fourth objection is that this tribunal lacks jurisdiction over claimants' claims for breach of FET because claimants elected to submit their FET claim to Colombian courts when they initiated an acción de tutela alleging such breach. Paragraph 1 of Annex 10G of the treaty states that if an investor of the United States has, quote unquote, alleged a breach of an obligation under Section E, in proceedings before a court or administrative tribunal of Colombia, then such U.S. investor may not, quote unquote, submit that claim to arbitration under the treaty. Notice the verb usage. If the claimant has alleged a particular claim of breach before Colombian courts, it cannot submit that claim to arbitration. The ordinary meaning of the word allege, in Spanish alegar, is clear and leaves no room for ambiguity. The specific terms used in this provision were chosen carefully and are not a mere drafting error. That's evident when one compares Annex 10G with Article 1018(4) of the treaty. The electa una via provision contained in that article, which applies to breaches of investment authorizations and investment agreements, uses the verb submit, while Annex 10G, which only applies to U.S. investors with respect to breaches of the substantive obligations, uses the verb alleged. This difference between the two electa una via provisions can also be found in other treaties entered by the United States, such as the Trade Promotion Agreement with Chile, the CAFTA-DR, and the Uruguay-US BIT. In this case, it is undisputed that Foster Wheeler and process consultants allege a violation of the treaty's FET provision in the acción de tutela they initiated in 2018 before Colombian courts. Under Annex 10G, alleging that violations prevents them from bringing a claim for breach of FET before this tribunal. Turning a blind eye to the text of the treaty, claimants argue that there are no material differences between Article 1018(4) and Annex 10G of the treaty, and that Annex 10G of the treaty really means submit rather than allege, pointing to paragraph 2 of Annex 10G in support of that position. The second paragraph of Annex 10G only provides a clarification that the election is definite, but does not modify or override the language of the operative part of the provision contained in the first paragraph, which is clear and unambiguous. There is no reason to depart from the ordinary meanings of the terms of the provisions, which says what it says, and it says alleged. Claimant's interpretation is contrary to the Vienna Convention. Not only does it ignore the treaty's express language, but also defeats the object and purpose of Annex 10G, which is to avoid the duplication of claims and proceedings. In conclusion, since claimants alleged the breach of the treaty's FET provision in Colombian courts, that election was definite and they cannot make the same claim before this tribunal. Finally, Colombia objects to the jurisdiction ratione voluntatis of this tribunal because claimants have not made a valid waiver, either formal or material, under Article 1018(2)(b) of the treaty. Article 1018(2)b of the treaty explicitly provides that in order to submit a claim to arbitration, the notice of arbitration must be accompanied by a written waiver to initiate or continue before any administrative tribunal or court or other dispute settlement procedures, any proceeding with respect to any measure alleged to constitute a breach of the treaty. Only a waiver pursuant to Article 1018(2)b of the treaty is an effective waiver capable of perfecting the offer of consent made by the contracting parties. To be effective, a waiver must comply with both formal and material requirements. As the U.S. observes in its non-disputing party submission, if all formal and material requirements under Article 1018(2)b are not met, the waiver is ineffective and will not engage the respondent state's consent to arbitration and the tribunal's jurisdiction ab initio under the agreement. In other words, an effective waiver is therefore a precondition to the party's consent to arbitrate claims. Let's review claimant's formal waiver in the notice for arbitration. As you can see in the slide, claimants added the text highlighted in yellow to the waiver. This waiver is without prejudice of claimants' right to defend themselves in the fiscal liability and any related proceedings, including any appeals. Claimants' broad reservation of rights is impermissible under the treaty because it renders the purported waiver meaningless and ineffective. To be effective, a waiver must be explicit and categorical, leaving no doubt that claimants will cease pursuing and will not pursue proceedings in a local forum with respect to the measures at issue in this arbitration. In its non-disputing party submission, the United States explained that the waiver provision, which is a no U-turn provision, requires an investor to definitely and irrevocably waive all rights to pursue claims in another forum once claims are submitted to arbitration with respect to a measure alleged to have breached the agreement. Claimants are simply not allowed to qualify their waiver however they like, as they did here. The tribunal in Ranco v. Peru explicitly stated that waivers are qualified in any way are impermissible, and that a reservation is not permitted since it undermines the object and purpose of the waiver provision and is incompatible with the no U-turn structure. The U.S. has echoed this view in its submission in this case, stating that a waiver containing any conditions, qualifications, or reservations will not meet the formal requirements and will be ineffective. Leaving aside the formal requirements, claimants have also failed to materially comply with the waiver requirement. As the Tribunal in Commerce Group v. El Salvador noted, a waiver must be more than just words. It must accomplish its intended effect and assure materially that no other legal proceedings are initiated or continued. Claimants have violated the waiver 4 times already, and they threaten with a 5th violation. Claimants violated the waiver twice by initiating an acción de tutela on April 23, 2021, and another one on April 28 of that same year. The 3rd violation came when claimants filed an administrative appeal against the ruling with fiscal liability, seeking to reverse it. The 4th violation is more recent. Claimants initiated a conciliation proceeding against the CGR before the Procuraduría, or PGN, while also threatening an additional violation, filing an annulment action against the fiscal liability proceeding before the courts of the administrative adjudicatory jurisdiction. As a matter of principles, claimants contend that reserving the right to defend themselves in the fiscal liability proceedings and other related proceedings is not contrary to the requirements of the waiver, and that the waiver requires claimants not to act offensively, but does not prevent them from mounting a defense. Claimants are wrong on both counts. Claimants' all too convenient interpretation empties the waiver of any practical effect. In claimants' view, nothing bars them from continuing to file appeals and judicial remedies to reverse the ruling with fiscal liability while pursuing at the same time this arbitration challenging the same measure. Simply put, claimants are trying to get 2 bites at the apple. Moreover, claimants' artificial distinction between defensive and offensive actions is nowhere to be found in the provision itself. The waiver bars claimants from continuing any local proceedings concerning the same measures alleged to constitute a breach. Let's be clear. To defend is to continue, because defending continues to give impetus, or in Spanish, impulso procesal, to a proceeding that may otherwise end or wrap up. Let's turn now to the violations of the waiver. Claimants argue that the two acciones de tutela as well as the appeal are not violations of Article 10.18.2b because they fall within the scope of the carve-out set out in Article 10.18.3 of the treaty, but that's incorrect. Article 10.18.3 provides that a claimant may initiate or continue an action that seeks interim injunctive relief and does not involve the payment of monetary damages before a judicial or administrative tribunal of the respondent, provided that the action is brought for the sole purpose of preserving the claimant's or the enterprise's rights and interests during the pendency of the arbitration. As the U.S. observed in its submission in this case, the exception in Article 10.18.3 applies in very narrow circumstances. It certainly doesn't apply here. None of claimant's actions sought interim injunctive relief, and none of these actions, if successful, would have the effect of preserving claimant's rights at stake while this arbitration is ongoing. That is probably why claimants initially invoked this provision in their counter memorial, but abandoned that argument in their rejoinder. The conciliation request is an additional violation of the waiver. Initiating a conciliation is initiating a dispute settlement procedure within the meaning of Article 10.18.2b with respect to the same measure at issue here. In their May 9th letter, claimants argue that the reference to dispute settlement procedures in Article 10.18.2b encompasses proceedings before a third party with adjudicatory power, but excludes dispute settlement mechanisms before a third party without adjudicatory power, like the conciliation initiated by claimants before the PGN. This distinction claimants want to draw is artificial. From a policy perspective, the point of the waiver in Article 10.18.2b is to prevent a respondent from having to defend itself in different fora. The conciliation before the PGN defeats that purpose because it opens an additional dispute settlement forum regardless of the fact that the PGN lacks adjudicatory power. Finally, if claimants ultimately decide to file an annulment action, they will violate the waiver for a fifth time. Quite ironically, given that this case is based on pure speculation about future breaches and future losses, claimants argue that the respondent cannot rely on a future event to support its claim of violation of the waiver because they haven't filed an annulment action yet. The only reason why Colombia is mentioning a potential breach of the waiver is because if and when claimants file their annulment action, this hearing will be long past us, and with it, respondents' opportunity to argue before this tribunal. It is important to highlight at this point that the treaty does not require claimants to abandon all their proceedings before administrative and judicial tribunals with respect to the same measure. It only requires claimants to do so in the event that they wish to submit a claim to arbitration. In other words, what the treaty's no U-turn structure does not allow is for claimants to continue their proceedings in Colombia and at the same time submitting a claim to arbitration before this tribunal, channeling the same measure alleged to constitute a breach. In their pleading commenting on the U.S. submission, claimants tried to save their waiver by arguing that the message which they complained in the notice of arbitration was the indictment order and that the waiver they submitted referred only to that indictment order. According to their flat logic, the tutelas, the appeal, the conciliation request, and an eventual annulment action against the ruling with fiscal liability do not violate the waiver because they do not refer to the indictment order, but to the fiscal liability proceeding in general and to the ruling. This is a clever argument, but the problem is that it's inconsistent with what claimants have been arguing in this case since day one. The measure they rally against is the fiscal liability proceeding as a whole, including the ruling. Because they clearly intend to continue with local proceedings, claimants now argue that they retain their rights to initiate or continue proceedings that challenge the ruling with fiscal liability until that ruling itself becomes the subject of a claim under Article 10.16. Are they telling us now that the only supposed breaches at issue in this case arise from the indictment order and nothing else? because that would mean that any discussion regarding other aspects of the fiscal liability proceeding and the ruling with fiscal liability would be outside the scope of this tribunal's jurisdiction. Ironically, this last-minute argument actually shows that claimants know full well that they violated the waiver. To conclude, claimant's reservation of rights is incompatible with the formal waiver requirement contained in Article 10.18.2b of the treaty. Moreover, claimant's initiation and continuation of administrative, judicial, and dispute settlement procedures in Colombia, including the recent commencement of the conciliation proceeding, is equally inconsistent with the material waiver requirement of the treaty. Thus, there is no consent to submit this dispute to arbitration, and the tribunal lacks jurisdiction ratione voluntatis over claimant's claims. I now turn it over to Dr. Frutos Peterson to conclude our presentation.
Thank you, Lisa. Dear members of the tribunal, as Ms. Ordonez said during her preliminary remarks, this is a novel case for Colombia, since it is the first time it raises an objection according to Article 10.24 of the treaty. But we submit to you very respectfully that this is a simple case because we have shown you that there is no breach, no damage to essential requirements under the treaty. Thus, claimant's claim is not ripe, not at the time claimant submitted the notice of arbitration, not even as of today, at this precise moment. What is more, there is no investment and there is no consent to international arbitration. Colombia respectfully requests that you, 1, uphold respondents' preliminary objections under Article 10.24 of the treaty and dismiss the claims submitted by claimants. 2, uphold respondents' 5 jurisdictional objections. And 3, order claimants to pay all costs and expenses in this arbitration, including respondents' attorneys' fees, together with interest thereon. This concludes, members of the tribunal, the presentation of Colombia. Thank you so much for your time and attention.
Thank you very much, Ms. Peterson. We are done. You have exceeded 10 minutes of your time. No?
They had 7 minutes left on their time.
Oh, really?
Yes.
I'm sorry.
We were counting. Thank you.
Brother, my watch. My apologies. So now we have the break for lunch, 1 hour, and we'll be back at 1:10. Thank you.
Thank you.
Bon appétit.
Bon appétit. Provecho.